Good morning, everybody, and welcome to this edition of Macro Pro and Friends. I'm Diane Cohen, Vice President of Client Relations and Education, and I'm joined today by Dan Mora, who is the President of Gemini, and he is the immediate past President of the CPP. Dan, can you tell everybody real quickly what the CPP is?
Yeah, thanks for the introduction, Diane. CPP is entrusted ourselves with advocating for proper legal discovery procedures and rights, and advocating to the DWC, to the DIR, and to the legislature.
Very good. Well, thank you so much for that. And as I mentioned, Dan is the immediate past president after serving 6 years. That's a long time. Hey, Dan, we always start these summer school series out with a question. Do you have a question you can ask our audience today?
I do, Diane. I'm curious what everyone's favorite summer vacation destination is.
Oh, that's a good one. That's a really good one. So in the control console, those of you attending today, please put in what your favorite destination is, and good morning to you too. I see some people wishing us some good morning. And Dan, why don't you tell us why they're typing in where your favorite destination is?
I would say my wife and I have been to Cabo in August, which you have to be heat tolerant, but seems to be, I would call my favorite summer destination. Cabo.
You know, I think mine is going to be Cozumel, because I love to scuba dive and it's so nice there and warm, and I could do it in February so I can get out of the cold of Washington State. So we see here, Chuck says his, he loves Disneyland. Ryan does Big Sur. Someone says always Iowa to see her father or his father. Oh no, it's Christine. Oh, hi, Christine. Someone said Lakes, another said Caribbean. Myrtle Beach is another. Monterey. Who doesn't like Monterey? We got here Yellowstone, Trinidad, anywhere on the coast, Yosemite, visiting all the national parks. Wow, a lot of Hawaii, Monterey, Upland, California. Now, I think that is a staycation, right? I think that's a staycation. All right, well, I am, go ahead and keep typing those in, but I'm gonna do a little bit of housekeeping before I turn it over to Dan and the others. And today's topic is really great. It's about copy services from the perspective of the applicant attorney, but they have kind of renamed it. When do copy services go too far, and how to object? I think that's outstanding. All right, so today's webinar is worth 1 CEU credit. You must be logged on to the GoToWebinar platform, so you had to use a link to get that. You should receive your certificate in 1 hour. If you don't get it within 1 hour, I'm finding a lot of people are saying they're finding it in their spam. So check your spam, and also check with your IT department, because it could be a firewall issue. If you have any questions, you could put them in where you jotted down your favorite vacation location. And if we get opportunity, we'll try to get those questions to our expert panel. But they did provide a copy of the handouts today, so make sure that you download those so that you have them nice and handy. So Dan, I'm going to turn this over to you and the others.
Excellent, thank you, Diane. I have to give Diane credit. We as the CPP have been around since 2018, and the three of us, introduced Mike Callan here, and Steven Schneider, the three of us has been on the board for 6 years. We founded in 18, but Diane is a new board member for us. So Diane, Mike, and Steven are going to carry the torch. I'm not going anywhere, and but it's really great to have Diane. Diane's a great asset, so we're really happy for her, and I'm happy to keep this legacy to protect and advance the long-term viability of the legal evidence procurement process. It's our mission, again, our sustaining objectives, a unified message, a trusted source of information, industry outreach, improved rules, improved collections. Here's the list of our member companies, and this is a good thing to take a screenshot of, though you'll get the presentation emailed to you if you'd like. These companies have committed to following a good process, and so you can trust these companies. And if you, in part of my presentation, it was really important is that if you don't trust, give us a call. Why are we called professional photocopiers. Well, this is the Business and Professions Code that outlines what we do. And you see there 22458, responsible at all times for maintaining the integrity and confidentiality of information obtained. So I understand it's kind of a dated term, copy service. Are we making copies? Well, we are making copies most of the time, and a lot of times they're digital copies. So, you know, the state hasn't seen fit to change this, and so that's who we are. A little bit about us. We had our annual board meeting yesterday, and I am no longer on the board, still helping out, of course, but you can see here Diane is not here, but she is our new board member. All three of us, all four of us have decades in this industry, so I hope that goes, you know, attributes to our credibility. Mike here, 26, 27 years in this industry, founder of Republic Document Management. Stephen Schneider here, 30 gosh darn many years, founder of MedLegal, co-founder of MedLegal and DocuCents. Myself, also founder of Gemini Legal and the current CEO. So this is what we're trying to accomplish here. We got a few goals and a few asks. We want to be very transparent. So, you know, take good notes and give good feedback. There's a presentation later this afternoon that is taking some opposite claims that we're making. So I really encourage you guys to do your homework, study this stuff. We're going to be putting a lot of codes up there and talking around them. Take screenshots and you know, do your own study on these things. That's basically what we do on a fairly routine basis. Is we got to go look at the law, we got to go look at the case law. Our goals here is to save you money, and we can by this information save claims administrators, insurance companies a lot of money. There's a lot of money spent on objections and quashes that are unnecessary, so we're going to highlight that significantly. We want to explore where we go too far, where copy services can take it too far, but also where you can go too far. Finally, questions and disputes are always best resolved directly with the service in question. Okay, it's the cheapest way, it's the fastest way, it's the best way, so we want to encourage that. Mike, Stephen, do you have any thing to add to the introduction before we get started?
You know what, I'll start first. My name is Mike Callan. Hello, everybody. Just want to say good morning. Thank you very much for your time today. I don't know who said that Upland is their vacation spot, but that's where I'm from, and that sounds amazing to me. So in any case, though, really, we do thank you for your time today. And Dan, what Dan was pointing out there, and I think something to highlight for you guys is that really, you know, one, the member companies that are part of the CPP have committed to doing business, conducting business in a way that is transparent. And is, you know, we're trying to reach out to the parties to, you know, to discuss these things with you and to, you know, to educate you. So part of this, I think, is about really saving you guys time. We know you guys are extremely busy folks, as are we. And I know that with these cases, they can drag on. And if we can save you guys a little bit of time and save you guys money, we think we might be of benefit to you. And so hopefully you guys take a little bit away from today's presentation and go into that next presentation, maybe with a little bit more knowledge and with the ability to maybe make an argument or, you know, pose a question that might be interesting to see the answer to. So thanks again for your time today. Stephen?
Hi, I'm Stephen Schneider. I also want to thank you for your time. It's great that when everyone can get together, you know, Dan was saying, the best way to resolve disputes is to resolve it directly with the service that's in question. And I think that's kind of what's going on here today is here's a bunch of, well, a couple of service providers in front of you that you guys are having to write checks to and pay for their services on a daily basis. And I'm sure you have, you know, questions and concerns. And so that's what we're trying to do is come in here and try to address those directly. And a little bit to that end is the CPP as a group. The concept is a healthy ecosystem. So the workers' compensation system itself, yeah, there's some disputes, there's maybe some, I don't want to call it animosity, but you know, there's sides, right? We call it aisle, and you know, both sides of the aisle. And the best way to resolve these things without a bunch of friction and extra cost for the employer and the insurance companies, and use of the actual state resources, is to, if everybody would know the actual details of the law of what they're allowed to do and what they're supposed to be doing. It gets into the weeds, and sometimes we're accused of being too detailed, but the only way we can truly resolve disputes in an amicable way is if we know what the law says and we all stick to it. And so the CPP members, they don't come into this group unless they're willing to abide by the law. You know, that you got to do things correctly, and you can't step outside of those rules. And so that's what we're here to talk about today.
Thanks, guys. All right, well, we'll get started. We have two major segments of this: liberal, discovery, reasonable, and necessary, and another section we'll introduce in a minute. I was told that we should summarize these cases and these statutes, and we did our best, but I want to give you all credit that you know how to read these things, and you know how to understand these things, and they're pretty darn clear. And I think that I'm an advocate for justice. That's what we're in this industry for. So this is supposed to be read by the layman. The layman is supposed to be able to read and understand these statutes, these regulations. And credit to Mike. Mike here was my first mentor in this industry, and he just handed me the book and said, "Hey, whenever you see a notice come through and you see a statute, a regulation, just read it." And that is a really good base that I've used, and I encourage my employees to do. So we're not going to dumb this down at all. We are going to read these things and kind of talk around them. And I want to also encourage you for your questions here. If you have any questions or challenges, please go ahead and put those up. We tried to pick the most important statutes, regulations, and cases that we could find. There's a lot. There is a giant library that we can share with you if you're interested, but we picked the best, the ones that we thought were the most clear and the best articulated for what we're trying to accomplish here. Again, liberal, discovery, reasonable, and necessary. Here's a CCP 2017-10. Unless otherwise limited by order of the court, in accordance with this title, any party may obtain discovery regarding any matter not privileged that is relevant to the subject matter involved in the pending action or to the determination of any motion made in that action, if that matter is itself admissible in evidence or appears reasonably calculated to lead to the discovery of admissible evidence. Okay, I think that's pretty important, and I think comp has it a little backwards in a way. And I think that discovery should be, it is granted, but there's still a lot of friction. There's still a lot of objections and quashes, and we'll get into that a little bit deeper. Here's a Labor Code 4621. The reasonableness and necessity for incurring these expenses shall be determined with respect to the time when the expenses were actually incurred. We get a lot of objections on reasonable and necessary, and that's why we're highlighting this and being significantly specific about reasonable and necessary. You guys can chime in whenever you want. I'll just keep going. So this is the copy service fee schedule, regulations 9980 through 9984, allowable services. This is really specific, and if you really look at those sections, those code sections, those regulations, you'll have a very clear picture about what is reasonable and necessary, because the WCAB and the administrative director has said that this is what's reasonable and necessary. The schedule covers copy and related services for records relevant to an injured worker. When workers claim, there will be no payment for copy and related services that are provided within 30 days of a written request by an injured worker for copies of records in the possession that are relevant. We highlight this 30-day rule, quote unquote, because it is, we get a lot of questions about it. I think it reads pretty clear that we have this holding period of 30 days. And it's my opinion that that holding day is to give the applicant side the opportunity to decide whether they want to subpoena records or not. But that doesn't change the fact that they have the right to do it. So again, this holding period, in my opinion, is simply just to allow the applicant side to determine whether they should or should not subpoena records. Mike, Stephen,
I'd like to point out a key distinction, and this is the right slide to do this. And that is, there's two concepts going on here. One concept is, I don't want to pay for those services because I think it's unreasonable. I don't think it's necessary. I've already got these records. I could give them to the applicant attorney, less expensive than that. So I'm going to object to the subpoena, or I'm going to file a petition to quash. Well, the applicant and the applicant attorney, they have the right to do discovery. And in the California workers' compensation system, there is, and we'll show you a case a bit later that points this out. There's this concept of liberal discovery in workers' compensation. So the applicant has a very broad right to do discovery. So it's not the appropriate place to do a petition to quash because you don't want to pay for the services. And that shows up in the panel decisions from the WCAB as well. They've directly said it, that if you're going to do a petition to quash, there must be some legal right, that the deposition itself was set up wrong, used the wrong forms of procedure, or it's stepping on some legal right that you have, such as a right to privacy, which is going to be rare, especially when the applicant's chasing, employer records or claims records. We totally understand there's a lot of, friction that happens around these petitions to quash because, you're the employer or the TPA, the carrier, and you don't want to produce these records. You feel like it's a fishing expedition. We just wanted to, get it into your mind to consider the applicant has a right to the discovery, but the copy service doesn't necessarily have a right to be paid for that. And the proper venue for you to address the fact that you don't want to write that check is after you've received the invoice. Now we're under Labor Code 4621, Labor Code 4622, and the whole process of collections. And we feel that, ever since the last fee schedule, copy service fee schedule change, where in 9982, Regulation 9982, there's now a provision that says if there's a signed order from a judge quashing the subpoena, then you don't have to pay the invoice. You don't have to pay for the services. Well, since then, we've seen this increase in petitions to quash. There's consequences to petitions to quash. It takes up valuable time at the district offices. It slows down your claims. And is it really that important? I think what we're here today to discuss is, what are the actual rights, both from the copy service side, the applicant side, and your rights to not pay for those services, or in the case of, a legal right is being stepped on and you want to quash that subpoena. We just want to make it very clear what we're doing, what we all should do to keep a healthy ecosystem. Copy services shouldn't be doing, a bunch of petitions that are unnecessary and taking up the district office's time, and we think it goes both ways on that.
And I think Stephen and Dan both pointed out liberal discovery is not only the law of the land, it's preferred. And if you consider the other side, the applicant attorney, his job is to discover what's going on with the person that walks into his office looking for him to represent him. And the courts have held that this doctrine of liberal discovery is what the system is about. So, I get that there may be this kind of knee-jerk reaction. Oh, I see some subpoenas from an applicant copy service. Object and quash and damn it, get people on the phone and start trying to make things stop so that they can't do that. I would argue that is it adds friction to the system, because now you got to get in front of a judge if you are going to file this motion to quash. So you're getting your attorney involved to file something. You've got to get in front. They have to, there's a meet and confer requirement for the quash. So now they've got to meet with the applicant attorney, and then they've got to get in front of a judge to get this thing signed. So all of this is happening to try to stop a $230 bill, let's say, that you guys may not necessarily agree with. We would argue, save that money, save that friction, save that time until after the services have been completed and you receive an invoice. So allow the liberal discovery to happen. If you have any objection to that, save it until the end. That's what we're trying to boil this all down to for you guys.
Yeah, Tim had a question, and this highlights the concern, or that what we're trying to do is separate and make a clear distinction between the service of discovery and the invoice itself. Okay, so Tim Mertz asked, since copy services are categorized as medical legal expense, should those services should be relevant for resolving a contested issue? Doesn't that affect the amount of liberal discovery that is allowed? Again, this is it doesn't, because liberal discovery is basically the law of the land, but payment for that, you could have some, you have the right to object to payment. And we'll outline that. And again, Charlene had a question: what happens when the records were served by the insurer and the DA to the applicant attorney prior to this subpoena? And we'll talk about that as well. Here's a couple of case law that are really important. Again, take a screenshot. You can see that also in the handouts of this presentation, you'll see our slide deck. So this is Superior Court. Statutes must be liberally construed in favor of discovery, and the courts must not extend the limits on discovery beyond those expressed by the legislature. So this is also important. I'd like that last sentence though, and I like to highlight this: selection of the method of discovery is made by the party seeking discovery. Selection of the method of discovery is made by the party seeking discovery and cannot be dictated by the opposing party. This Hardesty case is a WCAB case, really important case. Each party must make available to the other party for inspection all non-privileged statements of witnesses, which are his possession. And so this is also important. It would unduly expose him to the danger of surprise at trial. Here's a more recent case, the Cole-Monaco versus Secure Transportation and Bank. The public policy favoring liberal pretrial discovery that may reasonably lead to relevant and admissible evidence. Okay, that's also, we're just trying to hit that pretty hard and make sure that you guys understand that liberal discovery is it's just the way it is, and we think that there's some misnomers about that, so we'll kind of talk about that.
Pretty much every panel case I read coming out of the WCAB that's addressing these arguments and disputes over discovery, they quote this section that you see right here as just sort of, I think they just paste it right in. So this is very relevant language. And from the WCAB's position, they feel that it's the California legislature's sort of dictate that we shall favor liberal discovery. And that's really the point of this whole session today. Is we understand the resistance. We understand that sometimes you don't want to produce things, and we understand sometimes you think you don't have to produce things. But to have a healthy ecosystem, again, if we're going to be good stewards of our whole system here, which we all should be, we should stick to the rules laid down by the DIR, DWC, and the WCAB. And if we all do that, even if we don't like it, even if we don't agree with it, which, hey, oftentimes copy services don't agree with the way the rules have been written, but we have to abide by it to keep it healthy and to keep it efficient.
So these are some myths, okay? All of these are not true statements, so I want to make that clear. So the claims file is protected from discovery. We hear this asserted. Stephen, help us understand why that's not true.
You surprised me with that one. Well, there's a specific regulation, I can't think of it off the top of my head, that says that you have to serve benefit notices, and there's a certain time frame that you have to do that. You have to serve medical reports as you get them. Those are requirements that the claims examiner must do. but a claims examiner is not required by any regulation or anything in the system to produce the entire claims file of non-protected information. And we can all argue about what's protected. And again, we'd end up going back into the weeds, back into the cases. Are witness statements protected or not? Our position is they're not protected. We've got case law to show that. Just because you've produced the things that you're required to produce under the regulations, that doesn't mean that the applicant attorney has everything that he or she wants to see that's sitting in your file. And once again, totally understand that you don't want to do that. But you may even feel it's unfair. Applicant attorney can't get access to your attorney's file, and the applicant attorney can't get access to communications between you and your attorney. But there are many other things inside that claims file that the applicant attorney does have a right to, and uses a copy service to get those things.
This dovetails into, you talked about this, the benefits discovery, or excuse me, the benefits summary, and also records included within the claims file, and reports are the same as records. So this is an important kind of distinction that we like to make. I'll tackle a couple of these, like as Stephen said, the benefits summary, that's not the entire claims file. And I know you guys know this, but what is it? Regulation 10101.1 is a very explicit description of what is the claims file. Now, what is protected and what is not, again, I think Stephen pointed out, can be argued. But I like to point out that there is custodial rules that feed into this. Okay, so records that a doctor's records that are within the claims file, because of custodial rules, they no longer become that doctor's records, specifically because there's not a declaration that's signed by the doctor, by that custodian doctor. If you provide X report, X records of a doctor from within the claims file, that's not a legal chain of custody. We need to be really specific. That legal chain of custody is outlined in the evidence code and the code of civil procedure. These are areas that we just follow. We need to follow the rule. So if you have resistance from an applicant that says, hey, I know you say you gave me Dr. Smith's records, but I don't believe that this is Dr. Smith's records. They can say that, obviously, but they also have the absolute right to subpoena and get those records on their own independently. That independent right is absolute.
Yeah, there's a CCP code section, I believe it's 1561, that defines what a custodian of records is. And under that code, a custodian of records must have knowledge of how those records are processed. So a claims examiner does not have any knowledge about Dr. Smith and their office and how they produce records. So from the applicant attorney's standpoint, those records from Dr. Smith that you give him or her, that may not be complete. He has no confidence at all whether or not those records are complete. So it's helpful, and I think it's a good thing, and that you produce that stuff. And certainly when an applicant attorney serves the notice of representation and makes a request for all records in your possession, that's one of the things that, of course, should be produced and given to him or her. And at that point, if you then see a subpoena for Dr. Smith's records again, immediately after that, what that means is the applicant attorney doesn't have confidence in those records as being complete and everything that they're looking to see. And again, there is no labor code, no regulation, no case law I've ever seen that says an applicant attorney doesn't have the liberal right to go discover any other records that are in Dr. Smith's possession, in that custodian of records possession, that he or she doesn't have at the moment. And another important distinction here is, let's say that's exactly what happens. Let's say you have Dr. Smith's records, you serve them on the applicant attorney. Then the applicant attorney goes and uses, Republic Document Service to go out and get those same records. Now, it has to be after 30 days from when that applicant attorney requested those records. We know this because the copy service fee schedule has this provision. in 9982. However, as long as that happens, okay, they go out, they copy records, they come back, and you say, well, that's duplicative. 100% duplicative, unnecessary, I'm not paying those fees. Okay, the key here is records. So the key isn't, hey, you went somewhere and asked for records. The key is what was produced. So it's not duplicative unless nothing additional was produced that you already gave that applicant attorney. And that's a really key point, because we can start arguing about this and using the attorneys and using up the board's time to try to hear this thing. If you just go to the copy service and say, look, I served 101 pages of Dr. Smith's records, and I know exactly what they are. I got them right here. What did you go out and copy? If they went out and copied, even if it's 115 pages, you think, oh, big deal, it was 15 more pages. That might be the very evidence that the applicant attorney was looking for, because they've got some dispute. They want to go to IMR, or they want to go to QME, whatever it is. So just because you see a subpoena going to the same place where there's been another subpoena and you feel that you've served those records, don't get upset yet. Go to the copy service, say, how many pages did you copy? Did you get any additional information? If they got no additional information, I'm sure these two guys you see up here, I don't have a copy service. But if you ask these two guys, you say, hey, you copied 101 pages, and I already served 101 pages of those same records on the applicant attorney beforehand, I'm pretty sure they're going to say, all right, we're going to waive this one. We don't need attorneys. We don't need to file petitions. Most of these guys are reasonable people. And if they see that it truly was unnecessary, because, hey, from the copy services standpoint, how are you going to comply with Labor Code 4621 and prove that these records were reasonable and necessary when the applicant already had the same 101 pages in his possession? So that's a good objection, but before we make that objection, we actually have to make sure that the records are the same, not the location was the same.
And I'd like to point out, Stephen's right. We are people, we're trying to run businesses. Ultimately, we are trying to provide a service that helps the system move in a way that is beneficial for all. So as a service provider within the system, we understand you guys hold the checkbook. And with that being said, if you're going to call me, you're going to say, hey, Mike, I've got 101 pages, that here's the proof of service. I sent it to the attorney, and it's Dr. Smith's records. And you go, and how many pages did I copy? 101. Even if it's there's a facts page that's different or something. I'm not going to chase you into court or try to fight or argue this all the way down. If you can prove to me, or you show me that what we did is truly duplicative, I'm going to cut my losses right then and there. And on top of that, I don't want to create any bad blood with you guys. It would make no sense for me to argue something that is clearly duplicative, is my point. And I believe, and as the CPP, that's kind of the whole point of what we're trying to do here with this. We are all acting in that same way. So we are reasonable. Please contact us if you were to see that. But back to the liberal discovery thing, the applicant attorney not only has a right to do that, and the applicant is not only entitled to it, it's his job to do that. So if he gets those records, he goes, I think there's more, or he says, you know what, my client was seen a week after these records are done. I want to get the updated records. He's entitled to that. And if you guys are going to file motions to quash, it's unreasonable, it's duplicative, you realize you're really wasting your own time, and you're spinning your wheels and your money on fees that are not necessary, 100%. And if that applicant attorney goes in front of a judge, that defense attorney is going to lose on that motion to quash. And then what? Now you guys are out that as well. All for what? $230? So I'm trying to appeal to your guys' reasonableness as well. So anyways, I'll step down now. Thank you.
Yeah. Chuck asked the question on why the fees are higher, much higher on the applicant side. And that's a good question. And it's because of the friction, traditional friction that we receive, the cost of of applicant services to handle that friction. I'll tell you, we have a significant level of staffing that is necessary to answer objections properly, to go to the WCAB as necessary. That's why the cost is much higher. We have to wait too to get paid. In a lot of cases, our days outstanding on average is over 3 months. Okay, so there's some really great insurance companies that pay on time. We're whitelisted, they're happy. And then there's some that are awful. We're getting paid 25 cents on the dollar. And you know, that's part of the system. That's part of why the administration decided to give us higher fees than what you can get in the open market.
Well, and our fees are regulated. So they may be higher than what you are paying, you know, your contracted copy service. But our fees are capped and they're regulated. So we charge what the law allows us to do. You know, Dan's right. We do have a lot of, you know, collections on the back end. So our costs are higher, and that's why, you know, our fees are higher. But yeah, it's regulated.
There's one more really key point here. You might have compacts or somebody with a very low flat rate for their services. But more and more copy services are having to deal with what's called an ROI company. And these companies, they get in between the copy service and the medical facility, and they produce the records then to the copy service. And it's very hard to get rid of them. And for these flat rate defense oriented copy services, they're just tacking on, unless they're either using the capped fee of $230, which a lot of times, for example, MacroPro, they a lot of times will use the fee schedule and keep it at the cap. But those that aren't using the fee schedule, you think they're lower, you know, maybe it's $100, maybe it's $125 or whatever. Then you'll see an ROI fee. Sometimes those ROI fees are $500, $700. That same location from one of these guys on here is $230. So I'd like to see a study. I'd like to see if applicant copy services really are more expensive than defense copy services. And I would bet a lot of money that at least prior to this last fee schedule change, applicant copy services were actually lower because of that cap. And you know, it's not just ROI fees. Applicant copy services, first of all, you know, a defense copy service like MacroPro, they're like, you guys are talking about all these petitions to quash that never happens to us on our side. Well, yeah, because your side's paying your bill, whereas the applicant attorney's copy service side has to go chase the money from the payer. But applicant copy services have to deal with these petitions to quash, and if it gets signed by a judge, they don't get paid anything. So you might see a cheaper invoice sometimes, but what you're not seeing is when the applicant copy service can't charge for something, ROI fees, WCIRB pulls, when there's a quash, all these are take nothings. Limits on CNRs, you know, sometimes there's a certificate of no records, and sometimes it goes over the limit that applicant copy services are not allowed to charge for. So I'm not sure applicant copy services cost more than other copy services.
Yeah. Tim brought up another question, and this is in regards to if there's no dispute on medical treatment. And that's a great question. And Monaco addresses this, and this is making collections difficult, and we have to go back to our applicant. They ordered the service. We have to go back to the applicant attorney and ask them to provide proof that there is a contested issue that's related to the record. So yeah, that's important. You know, I'm glad you brought that up. And Charlene talked about asking for records that have already been provided. Again, we kind of went over this, but they have the right, the applicant has the right to independent discovery. And a lot of times just on the base, they just do not trust the records that are coming from the opposing party, and they have that right not to trust. We have
So
Angelica.
they have the right to that discovery, but the copy service doesn't have a right to get paid unless it's reasonable and necessary. And so if you've got the exact same pages that were already served, you've got a good objection. Otherwise, it's not a good objection.
Well, and the point here too, once again, is that first and foremost, these are definitely legitimate questions that you guys should be asking. The venue is not to try to file a motion to quash, to object to these. It's the applicant attorney is still, liberal discovery is still allowed. Allow them to go and get it. You guys object or should object on the payment side of things. And that's where we can have our conversation about it. Sorry, go ahead.
A couple other questions. Angelica asked for what does ROI stand for? This is release of information, and these are giant companies that go to hospitals and contract with the hospital for legal and proper release of information. That's what they do. Let's move on to the next portion. This is good cause to object or quash. Okay. So here's proper process, and this is where we keep kind of pointing this out, and we want you guys to really get this point that there's a differentiation between the right to obtain the discovery and then the obligation to pay. So we keep making this distinction. As we've said multiple times, if we mess up on the process of discovery, that is a viable, reasonable, good cause reason to object. If we mess up on that process. Stephen, you kind of were talking earlier about, is it time for me to show that case law? Do you want me to pull that guy up?
Not yet.
Okay.
But again, we don't want to get too deep into the weeds on this stuff. However, when it comes to motions or petitions to quash and things like that, again, what is the law? And the law, unfortunately, is sort of unfinished and fuzzy at the moment. And that's because when California used to operate on this CCP 1985, and 1987.5 subpoena duces tecum. That was the way things were done, whether it was a deposition or trial. Well, when California went and did the Civil Discovery Act, they created a whole new body of law that covers depositions. Well, they also, legislature went into Labor Code 5710 and actually incorporated that Civil Discovery Act into workers' compensation and says all discovery should be done as done in the civil courts at the Civil Discovery Act. What happens is the WCAB still has their regulations governing subpoena, duces tecum, and subpoenas. That has been unchanged. And so subpoena duces tecum requires an affidavit of good cause. A notice of deposition actually doesn't. And so a lot of defense attorneys will want to talk about the affidavit of good cause is too broad. It's not, the signature of that affidavit is a digital signature and that it's invalid. When an applicant copy service is chasing party records, so that's employer claims records, even if they're using a subpoena duces tecum, that's what they serve on you. They're actually serving a deposition notice under this California Civil Discovery Act, and they don't have to have an affidavit of good cause. They do it because they don't want the friction. They don't want you to complain. That signature isn't required. The whole subpoena isn't required. They could just serve you a pleading. And in fact, when I was in business, we actually stopped using subpoenas, and oh boy, did it cause turmoil in the industry. State Fund got really upset with us. They wanted that subpoena. There's no fee required. Party to party depositions, especially records only, there's no fee requirement. That's only for non-parties. So, this slide is about good cause to object. There's a lot to talk about here, and it's complicated. Just back up again. This is going to be a $230 bill. What is the value of going toe-to-toe with somebody in an area of law that is currently messy, we can send you, and maybe Diane can post a case where you see the WCAB commissioners looking at this and saying, yeah, there's a problem here. Our regulations don't really comport with what's in Labor Code 5710. It's important because you're going to get a defense attorney saying, hey, give it to me. I'll fight these guys. It's like taking candy from a kid, you know. I'll get them on all these little technicalities that I'm going to find in 1985, 1987.5. But you know what? Eventually, copy services and applicant attorneys are going to start holding you guys accountable for that. But that is not proper and legal, and it's a waste of time. It's wasting the district office resources, and it's just friction that is costing the employer money that is unnecessary. You got a problem, you don't want to produce certain things, you're required to do a meet and confer if you do a petition to quash. So you have to talk to that applicant attorney anyway. At least you got to reach out and try before you just go straight to these petitions to quash.
Yeah, great lead in, Stephen. And here's the well, I'll go here first. And this is our, where did we go? Sorry about that. Yeah, here we go. Okay, so this is what Stephen's talking about for a good cause. Okay, here's what's required. You're required to promptly serve a written objection specifying the error or irregularity at least 3 calendar days prior to the date for which the deposition is scheduled. And then C says this motion shall be accompanied by a meet and confer declaration under 2016-040. Also CCP 2023-020, notwithstanding the outcome of the particular discovery motion, the court shall impose a monetary sanction ordering that any party or attorney who fails to confer as required pay the reasonable expenses, including attorney fees incurred by anyone as a result of that conduct. We're trying to give you some pause to object, give you some framework to object, and I hope that this helps. The last one there, this is Code 107.86. Failure to comply with the requirements, timelines, and procedures set forth in these labor code sections, defendants shall be liable for the medical legal provider's reasonable attorney fees and cost for sanctions.
So again, I think that the change in our fee schedule, where you don't have to pay an applicant copy service if there's a signed motion to petition to quash signed by a judge, you don't have to pay any invoice from an applicant copy service. Since then, we've seen this sort of wave building of petitions to quash, where defense attorneys see this as a way to block the applicant copy service from being able to get paid. What we're trying to tell you here is we're responding to that. We're responding to it as a coalition. We're responding to that with the administration, because what's been happening really isn't the right way to do things. And there are sanctions, there's code sections where you can be held accountable for sort of abusing the system, misusing the system, making objections and petitions to quash that really you didn't have a right to. And that was why I was bringing up this concept of, you know, the code being out of date somewhat, and that the fact that a subpoena duces take them, you're going off, if you go off into 1985 and 1987.5 of the CCP for your objections and your motions to quash, you're in the wrong place. That's for trial subpoenas. That's not for deposition subpoenas. And you know this, Labor Code 5710 tells you depositions are handled over here in the Civil Discovery Act.
Well, you know, one of the things, we get this, we understand, you know, we don't want to pay, so we're going to quash, you know, and I actually had a conversation with an applicant attorney last week who used to be a defense attorney. And he's like, I filed all kinds of motions to quash your guys' subpoenas. And I'm like, and what was the basis? He's like, well, because it was duplicative and unreasonable. And I'm like, you realize that those are not reasons to file a motion to quash, that you have to, you know, your motion to quash really should be based off of the process or the merits, you know, that the paperwork was done incorrectly or the timelines were missed. He's like, yeah, I know that. He's like, I still did it. I'm like, well, why? Why would you do that? He's like, well, I had to do something. I had to do something. I had to show that I was doing something. And my point in kind of telling you guys this is that, you know, defense counsel is going to do what they need to do to represent you guys. We understand that. But if you guys are armed with information, you can dictate whether or not you want him or her doing that or spending their time on something else that you may need them to do. Trying to quash the subpoena, it's going to lose in front of a board when the applicant attorney shows up. That's a fact. So because of liberal discovery and what the courts have held. So just don't waste your time. Don't waste your money. We know you guys are busy. Got plenty of time to do other things.
We are at 9 minutes. I'm going to try to speed this up. I just want to point out section or regulation 9984 talks about the need for an EOR. So it's crucial that you also do that. And again, we're pointing out that failure to comply with these requirements, you see here 10786 is going to get you into a little bit of hot water that you probably don't want. Here's some more things that are going to hopefully dissuade you from objecting, and just pick up the phone and call if you have a question. This is a 4622 med legal expense that is not paid, is increased by 10% with a 7% per annum retroactive to the date of receipt of the bill. 9981E, bill must be paid or contested within 30 days. The unpaid portion of the bill sum will be increased by 25%. Do the math. Is that as much as it costs to take this to court? I don't know. Okay, so real quick, we'll touch on 193 or 139.32. I just want to say that this is a very, how do I say it? I think it's not very
provocative.
Powerful. It's not very powerful. I think if you think that this code is powerful to start holding copy services accountable, it's probably not. Except as otherwise permitted by law is unlawful for an interested party to refer a person for services. I want to highlight that. Refer a person for services provided by another entity if the other entity will be paid for those services and the interested party has a financial interest in. Okay, so this is where people kind of try to catch us when it comes to like red carpet service or any sort of thing that's gratuity based. And the regulation, the 9982 really explains what is to be, frames up our services. 80, 81, 82 frames up what we can and can't do. It doesn't talk about gratuity. It doesn't talk about, actually it says that it's not, we can't charge for it. We can't charge for tabbing indexing. We can't charge for pagination. It's all one fee. So we're not, overcharging for providing, for example, indexing. You probably have a different arrangement with your defense services, and I think that you should be paying for those services because they are a very, very good service. Another reason why we are paid a little bit higher, at least from a fee schedule perspective, than the defense. I don't know, you guys have anything to say about 139?
Well, just follow up that I think the key point that you're trying to make here is that code section was put in by SB 863 in 2013, and there was a ring that was taken down at that time where they were doing, it was, I believe they went under the name Central Legal, and they would put up billboards and they'd go around and they would solicit people to become injured workers. And then in response, any attorney that got one of these referrals was required to order services from their companies, and copy service was one of those. That was legitimately a situation that was illegal and should not have been done, and they got arrested. That's when a copy service goes too far. And the point here is this Labor Code 139.32 was I think specifically written to combat this particular ring. And the way it's worded, it says over and over for referring a person for services, and copy services do not get a person referred to them. A copy service has no ability to decide what services they're going to provide. A copy service, now they're responsible to show you that a party, the applicant attorney, actually requested the services. That is true. But that's not a 139.32 violation. That's a Labor Code 4620 requirement that medical legal services have to be requested by a party. It's not provocative. It's a simple thing. If you question it, if you think the applicant attorney didn't actually order the services, talk to them, talk to the copy service, say, hey, show me where they actually requested those services. They'll be able to do it, even if it's just an email, even if it's a documentation of a phone call, whatever it is. And I don't know of anybody most applicant attorneys are not just going to say, sure, do whatever you want in my cases. I think that's going to be pretty rare. Now, do they say, hey, if you'll help me fill out these forms, if you'll help me fill out the request, I'm good with that. But, don't do anything crazy. Like, don't do anything that I'm not telling you to do. And all of the coalition companies, they're going to be able to produce for you evidence that the applicant attorney actually ordered their services.
I would only say that 139, if you take a broad perspective on 139, I think if it's a quid pro quo, it flirts with it. So if we're providing X amount of services for X amount of orders, or X amount of gratuity for X amount of orders, that to me is the gray area I don't want any part of. And we've advocated to all of our members that is the wrong way to go about any sort of gratuity. And that goes to these points of these myths, and we're talking around this. Order taking is not illegal. We're assisting. Where does the service stop and end is the question. And why should you care if it's a flat fee, if we're actually taking the information? And I'll tell you, it improves quality because we know what we need. We're the discovery experts. The attorney is the attorney expert. We're not attorneys. We need to make that clear. But we're the discovery arm of it. So sometimes information, we need to get good information. Quality at the source is just so important because it's a waste of time. It's a waste of energy.
Well, a perfect example would be, an attorney asking for records from Kaiser Oakland, and we as a copy service know that those records are held in Hayward or wherever it might be. We know that. So when the attorney says, hey, Mike, can you please subpoena these records? I'm going in and filling out the system so that he has it on his website and so that it's in my system. And, that's how we do it. And that's how we keep it clean and keep the process as smooth as possible.
Yeah, a couple other points here. Who decides that records are duplicative? Who has that authority, that really specific authority? This is an in-camera, like if you want to get real specific on the codes, an in-camera review is probably the best, most valid way to see if something is duplicative. Both Mike and I have experience scanning records in the field. And I'll tell you, it's not that I'll scan right next to somebody that's a defense service. They pick and choose because they're trying to save some money, or they feel like X report isn't important. Put yourself in the shoes of the applicant attorney, and everything is important. Everything is important, right? This is a whole body WPI situation where everything is important, right? I'll also say that we did an internal study. Both Mike's records and my records were cross-referenced with a large defense company's records, and it was less than 2% of those records were literally identical. So who determines whether it's duplicative? I think that is it worth the challenge? I would just say it's not. I don't think it's worth the challenge. The other point here is that copy services must stop working as soon as they receive a motion to quash, which is untrue. We stop working when we receive a signed order from a judge. That's when we stop working.
We should probably close this pretty quick. We're coming in, it's 11 o'clock. We've also got lots of questions that went kind of unanswered, and I'm feeling bad about that. Maybe we can get
stay. Yeah, if you want to stay, we'll answer your questions, but we all have email addresses, okay? So yeah, get a hold of us. Charlene brought it up. Hey, it's hard to get a hold of the applicant attorney. Yeah, give us a call, shoot us an email. Again, we're pointing out that the total cost of the system is less than 1% for copy services, so keep that in mind. We'll rush to the conclusion here. Workers' compensation is an evidence-based system which requires liberal discovery. In my opinion, point number 2, there is zero monetary or time benefit to file a dispute with most copy services, okay? We encourage you guys to whitelist those that you trust. Remember these myths. The fee schedule is intended to reduce friction, and it has, I'll say that it has over the years. Dispute with good cause and with the appropriate legal process, okay? Go to the source, statutes, regulations, case law, and directly to the service providers. It's always best resolved directly. So let's, if you can hang on, we'll go through some questions here and answer. Edwina, I'm going to encourage you to email. That's a big one. It's a long one that you got there. And let's see. How many copies do we need to pay for? One is paper, one is CD. We pay for both. Yeah, you only pay for one. And again, refer to 9980 through 9984 for that clarification. They're short regulations. Don't be intimidated by them. Read them, and you'll see what you can pay for. Another question had to do with receiving subpoenas for personnel file, payroll file, x-ray, having multiple subpoenas for one address. Let me clarify this. So we need to get a declaration signed by the custodian. So you may have, we try to avoid this at all costs because we know it is contentious. But if we go to a hospital and they have their billing records separate from their medical records, those are two separate custodians that we have to serve a subpoena to both of those and get a declaration from both of those custodians in order to satisfy the need. Go ahead, Mike.
Dan, can I get one in? This one, I was hoping to get kind of Stephen's input on it. It's from Tim Mertz. It says, wouldn't a petition to quash be appropriate if the subpoena for the claims administrator's legal file, which is privileged?
Well, anything that is a communication between the person's attorney and them is privileged. And you just assert the privilege. You don't have to quash the whole subpoena. You just assert your legal right to various protections and privileges. And that'll be an argument that'll have to be decided by a judge as to whether or not it's truly protected. But yes, any communications to or from your attorney are protected.
So would the motion to quash or petition to quash be the appropriate vehicle?
That's up to the person doing it. Is it appropriate? Well, if every single document in that legal file is a document that is to or from the attorney, then I think that it would be appropriate. But that may not be the case, and there could be other documents in that legal file that aren't necessarily between the attorney and his client. And there's a lot of case law out there on that exact situation. So we've got a body of law to help us with that.
D said, if there's a motion to quash, are you still able to get those medical records? Again, the motion doesn't stop the action. So we still may be getting those records. Let's say we get a signed quash, though. Those records are inadmissible in court. Now, I've specifically talked to a judge and I asked, hey, would you accept evidence anywhere, anytime? And she basically said, yeah, you can have evidence on the back of a napkin, and I would take it into the court. But I believe if there's a quash, that literally stops like that evidence from being submitted.
The process is you object, and if you're the deponent, if they're trying to get your records, if you object timely, then the fact that you don't produce those records can't be held against you. So you can just go ahead and go through with the copying of the records, and you can assert various, I didn't give you this because of this protection, this legal reason. But if you say, hey, I've got some documents in here from my attorney, so I'm going to not produce anything, and that's not reasonable. You can simply object to the things that you don't want to produce, and now it's up to the applicant attorney to then file a motion to compel that says, hey, you got to give those records up. So you don't have to always do a quash. You can just object.
So that's most of our questions. Stephen is our scholar at CPP, and he last minute threw this up to me and wanted me to put this up. Stephen, you want to kind of outline this for those that are hanging around?
First, can you roll up to the top so they can see this case so that they could go get it themselves and look it up? Okay, so this is a recent panel case. Russo, it's a Robert Jones versus Russo Brothers Transportation. And the reason why I asked Dan to include this at the last minute is this is the commissioners going through the problem of Labor Code 5710 authorizing depositions within the Civil Discovery Act, but people always want to use the old section 1985, 1987.5 because of the subpoena duces tecum regulations. And I don't want to get too deep into the weeds, but this paragraph right here that's highlighted, this is where the commissioners of the board are saying, hey, look, in California, we have this, we encourage liberal discovery. And what this paragraph here is saying is just because you don't feel that you should have to produce these records, or it's unreasonable or unnecessary, none of those are a reason to do a petition to quash. There has to be a legal basis that comports with the CCP to do that. And they go on down in this case and they say, if your problem is you don't want to pay for it, you should do that through the copy service fee schedule, not a quash. That is kind of what we've been covering throughout this whole session today. Is if it has to do with you paying for the services, that's not the right thing to do. Is not to do a petition to quash. You do a petition to quash because they didn't give you enough time, that they didn't use the right forms or procedures, they didn't serve the right people. I see all the time, well, you didn't attach a notice to consumer. Well, applicant copy service represents the consumer. They represent the employees. So why would they serve themselves with a notice to consumer? That's not a reasonable, cause to do a petition to quash. And again, I think as a coalition and with the applicant attorneys, this has got to stop this friction just to get in the way. Like Mike talking to his friend that was a defense attorney saying, look, I got to do something. Copy services shouldn't be trying to get in the way and trying to get paid for things that are clearly they're not allowed to get paid for, and keep pushing for it. But it goes both ways. We need to protect the ecosystem. I don't know about you guys, but like I can't stand the fact that we get so many changes to this system. The Matthew Bender Labor Code book used to be this big, and now it barely fits on my desk. It's like the system keeps being amended and changed and getting more and more complicated because we're all not really living by the rules. And so it has to get more and more detailed. So we're advocates of, hey, if we did it wrong, we should go away and we shouldn't bother you anymore. And if we did it right, you shouldn't be bothering us. And if you're concerned and you think that, hey, this is duplicative services, just look at the page counts. And if the page counts are pretty different, come on, that's just not a good objection. It has to be duplicate records. It doesn't mean you both went to the same place, because you could have ordered a limitation on the records that you wanted copied. You could have only wanted the last year, and applicant attorney wants the last 5 years. That wouldn't be duplicative. Call the copy service up, work it out. Don't go through your bill review company. They're going to tell us that our medical procedure wasn't authorized, and we're going to go, what the heck? What are they talking about? Bill review, I'm telling you, I don't know why this goes on, but I almost never I never pick up an EOR and say, oh, that's a good objection. We should talk to them about that. It's almost always, what the heck?
That's a whole other
Jill
one
and
of these web.
It is. And we actually had somebody ask if we could do this again on the same topic. So I think the people who attended today really appreciated the information. It was great that you guys answered the questions. We appreciate that very, very much. So I just wanted to remind everybody that they should be receiving their certificate at in approximately 1 hour. If you don't get it, check with your IT department. But we also have again this afternoon the defense side of this topic. So be sure to tune in for that. I did get an email. There is a glitch on the rehab webinar. So if you are signed up for that tomorrow, know that you will probably get a new link because there seems to be a glitch with the current link, and I am working with GoToWebinar to see how we can fix that. But thank you very much to our audience for making me aware of that today. And again, gentlemen, thank you very much for putting together this presentation. It was very educational, and we are delighted to have you join us. Until the next
Thank
time,
you, everybody.
bye-bye, everyone.
Thank you, Diane.
Thank you.
Thank you.
Thank you, Mac Pro.
You're welcome. Happy to do it.